Hi, today is the fifth law video, so it's on breach of contract and remedies. It's on 15th of March, so I'll try to do it in about 25 minutes, but usually a lecture will be 3 hours. So what is a breach? First, I'll cover what is a breach and what to do when it has occurred. What are the different types of terms? How can you terminate a contract? What are the remedies? And how do you calculate expectation loss? What are the limitations to claim damages? And conclude. So what is a breach? A representation is something that the seller tells you to make you come into the contract before you come into the contract. So for example, when I study in the law college will say, we got all these good lecturers, we got all these benefits, we got all these extra classes, we got overseas lecturers to come and teach you. All these things are not in the contract, but they are representations, right? Whether they form representations or not, okay? They have different rules to follow, whether it follows representation. But today we will consider focus on what is a term. So a representation can also end up included in a term. So my understanding is, if the representation is a term, you have to sue under a breach of contract already. You cannot, because once it is a term, then yeah, it's a term. So what is the difference, right, between if a representation you sue under misrepresentation, and you have to rescind the contract prospectively, means from the past, assume the contract didn't exist, we didn't enter into the contract, so you have to give me, I have to give you back the car and you give me back my money, now of course sometimes you already drive the car, so the court will say you already drive the car, you use the car for 6 months already, how you want to go and give back the car, right? Then you have to claim damages. But a term, you claim, you rescind the contract. Rescind means terminate the contract, but you terminate, the effect is prospectively. So whatever obligations and whatever benefit performance you have done before, all cannot be recovered. You only can recover from the date of breach. Right? So a good lawyer will be able to choose. Okay, he will say, oh no, this is a term, no, this is a representation. Okay, because uh, um, you a representation, let's say you ordered a car or you ordered something, a 10,000 thing, but you only pay 5,000, so you want to argue it is a term, okay, because it is a good bargain. But if it's a bad bargain, you pay 10,000 but the thing is only worth 5,000, I want to come out on contract, I regret entering the contract, I want to, I want my money back, cancel the contract, so you want to argue it is a misrepresentation. Okay. um Yeah. So in exam will come out with a problem question, and then they will give you, what are the facts. So if you look at the question, it says uh, whatever the parties talk about before signing the contract lah, then most likely it's a representation. Okay. A contract normally, if it is a term, means you must go through rules of incorporation. Means you got express term, you got implied term. Express term is whatever is written in the contract or verbally agreed. Whatever is implied means whatever the court will help you put into your contract. Okay, they got different rules how the court will put terms into your contract. So a term question, you have to talk about incorporation, whether the term has been incorporated. Misrepresentation, you will talk about whether it's a fact that induce you to enter into the contract, a material fact. Okay. What do you do when a breach has, sorry, this is misspelling, has occurred? So uh, when one party renounce the contract, renounce means he break the contract. He can break by words, he say I'm not going to do this anymore. He can break by action, means he never go and do it lah. So this is very dangerous, because if you think that he go and renounce the contract, and then you also go and terminate the contract, but end up he say, hey, I didn't renounce the contract mah, you only what. So and then now you end up the party that is in breach of the contract, and then he will sue you for damages, counter sue you. So you have to make sure that he has really renounced the contract. Okay. Different lawyers will advise you accordingly how you want to document all these, write letters, letter of demand and all those. So you can terminate and sue for damages, or you can affirm and sue for damages. Affirm means you go ahead with the contract lah, right? But you sue for just the damages. So terminate, if you normally terminate if let's say the guy is going bankrupt or it's very hard to get back your money. You sue him also, maybe he got no money to pay you. But to terminate is not so easy because it has to be, later you will see that you have to be a condition or innominate term. But warranty you cannot terminate. Damages can be claimed until the time of termination. So from the day he breached the contract until the day you terminate, you can claim damages. Some say you can even claim until the day the case go to court. So if you are a contractor, right, and you have to pay liquidated ascertained damages to your developer, every day you have to be paying him because your subcon delay your construction. So until the date it goes to court, you'll be claiming every day you have to pay all those lah. So this one, it depends on the cases and the countries. So how to classify terms? You have to see whether it's a condition precedent or condition subsequent term. So condition precedent is something must happen before the obligation arises. Some condition subsequent is you must perform something in order for something to happen. Condition precedent you cannot blame him because something haven't happened yet. Thing haven't happened yet, so he is not in breach of the term. Okay, independent or dependent on defendant's performance. So some say you have to pay rent. One side have to pay rent, the other side say you have to maintain the property. If the other party don't want to maintain the property, so is it dependent on you paying the rent? You still have to pay the rent whether even though he didn't go and maintain the property. Just because he didn't maintain the property, you cannot say it is now I don't have to pay you rent. So it is, you have to see now. And then is it divisible entire? Some terms, right, the moment you breach one term, the whole contract, all the terms are grouped together. So the whole contract is breach. Some is divisible. So one term is breached, but the other terms still are not breached. So the contract can be divided. Okay, if it can be divided, you have to see, is it a warranty condition or innominate? Last time they were only warranty and condition. Warranty means it's not serious. It's not an important term. You cannot terminate. Condition is very important term. You can terminate. But they say sometimes the term can go either way. So they call it innominate term nowadays. They say you wait and see what are the losses you suffer. So if, for example, if the ship say you have to be seaworthy. So if the person forgot to mop the floor, he didn't mop the ship floor, so it's dirty and all, right? You can say it's not shipworthy. Can you terminate? No, because the consequences are not serious. But if the ship is going to sink, cannot move, that is a serious breach, right? So you will be able to say that it is, you'll be able to, it's a serious breach, so it's a condition. So termination is a very high threshold. Courts don't want parties to break their promises. They don't want, you already promised one side, you cannot, they don't want you to simply terminate. So they use words like, if the term goes to the root of the contract, it is a fundamental, is substantive failure, or frustrates the contract's purpose. The whole purpose of me entering this contract is for you to do this. If you don't do this, the whole contract is useless. Then I can terminate. So classification by parties. Some parties will say everything is a condition. But not necessarily it will stand up in court, because the court will say, even though you call it a condition, there are ways to say that this is not a condition. Actually this is only a innominate or warranty. And if you want to terminate, you have to notify the other party. You cannot simply just don't do your part. You have to tell them, now I think you are in breach of contract, I want to terminate. And once you go and terminate, you cannot take back your termination anymore. Okay, it's irrevocable. And if you don't want, of course you can just go ahead. If you want to maintain the business relationship, you can affirm and then you ask the person to compensate you. But you see, that's why normally parties, it's only a last resort. You don't want to go to court. Okay, because go to court you take 5 years, 7 years, and then you take a lot of money to pay your lawyer fees and all. So they will settle it lah, but they settle it also, how do they know who is right, who is wrong, how much should I pay you? So it's all based on what the law is. The law has a way of calculating, and then you pay lah. But then you have to initiate action first. You need to send them letter of demand, and then you file a case in court. First, you threaten legal action. They don't do anything, then you file a case in court, and then you end up bargaining lah. And then yeah. So you got a few ways to calculate damages. So one is this is three expectation loss, reliance loss, restitution. Expectation loss means if let's say you are a scientist, you work for a company, you develop a product, let's say the product is worth 10 million, right? So the company can sell your product, let's say you develop iPhone or something, this company can sell that technology for 10 million profit. But your salary, let's say, is only 10,000, right? So the company will sue you for 10,000 loss because they lost expectation loss, right? From you, because they expect from the performance of the contract 10 million profit. But your salary is only 10,000, but you no choice. This is the main measurement. This is the main purpose of remedies. I don't know why, but over the years, English legal cases, they go for expectation loss. Right? But you can see that it is very dangerous for small parties when you go into contract. Let's say for services, you throw the rubbish, you clean the floor, or small things. You supply something, but you don't know, the other side can be can incur a lot of expectation loss, even though the contract sum is very small. So reliance loss is more for me. It's like misrepresentation. Means if you just pay me back whatever you pay lah. So I give you back my car and you give me back my money. Restitution is I already give you all the benefit. I gave you all. Let's say I gave you services. You must pay me fair value of the benefit you get or the cost I incurred. Restore. And then agreed sum is like if I agree to cut your hair for $10, I cut your hair already. Now you must give me $10. I don't care about expectation loss or reliance loss. I just want the agreed sum. Sometimes all this money is not enough. I want you to perform. So like if you are a singer, singer, you don't want to go to a concert. Let's say somebody asks you to perform and then you have to go and sing at his party or what and then you are not feeling well or you're sick or what. The court normally don't want to go and force the singer to go and perform, right? They don't want to force parties to go and. That's why it's not the primary remedy. Primary remedy is if you incur financial loss, they will compensate you for the financial loss. If the guy don't want to teach you, he don't want to cook for you, then you just get whatever loss you suffered but in monetary value they don't force unless the things you are buying is special. Okay, unless it is non-replaceable, money cannot compensate. Like if you buy a piece of land, you want to build a property there, okay, you cannot replace the land with money. You want to replace a house with money, then they will force you to sell that property, right? Or the injunction means they will force you to stop doing something. Okay. So how do you calculate expectation loss? You got three methods. Diminution of value means the reduction, the value that you're supposed to give and the value that you actually got. What is the difference in the value? This is you need some calculation okay, how to calculate this. And it was based on the court. The lawyer will argue, this is the diminution in value, but the judge ultimately he will decide how much to award the damages. And cost of cure. Sometimes cost of cure is can be the same. Let's say you buy a Mercedes Benz, you buy order S class, but you only give you E class. So you need now the E class is 300,000. You need another 200,000 to buy an S class. So this is cost of cure. It's more for contractors. So if you build a building, the building got defects, the building got cracks. So you need to repair the building. So whatever cost you incur to repair it, you can claim. You can get compensation. But it depends on not so intention. What is the intention of the claimant? Okay, if the claimant like this famous case we study called Ruxley Electronics, if you see the claimant build a swimming pool, okay, he got a contractor to build, but the swimming pool he wants to dive in the swimming pool, like to jump in the swimming pool, but it's only like 5 mm or 5 cm shallower than he's supposed to be. He says, now I want to rebuild, I want to take out all this swimming pool and I want to do again the swimming pool. You know. So the court say no, it's not proportionate ma. Now it's only a bit shallower, you know, and you got no intention to go and repair it. You just want the money only ma. You're not going to not going to, you know, rebuild the swimming pool. So I'm not going to give you cost of cure. I'm only going to give you loss of amenity. Loss of amenity means loss of enjoyment. So you only got like how many? I don't know, like 10,000 pounds or 15,000 pounds. And this is not much one amenity. Okay, let's say you come into a contract to buy a car, and then you take the car for a vacation. Halfway your car break down. You have to go in the hot sun. You have to call a tow truck to come, right? Then can you go and tell Mercedes-Benz, you see, I wasted, you know, my whole vacation is spoiled, you know, I bring my whole family there, and then, you know, all my baby cry, my children cry, and then, you know, I suffered so much, you know, all, you know, you have to compensate me, you know, sometimes we enter into contracts, right, is more than financial loss, non-financial. Let's say I send my pet to the vet, you know, the vet never do his job, and then the pet, you know, never get cured. To me it's worth 1,000, but for the pet, the vet will say your pet is only worth 20 ringgit. I will only pay you 20 ringgit. So loss of amenity is possible. You can claim for non-financial loss, but it's not easy. Okay, only recently they are more of this. Okay, last time no one. Traditionally, a few 50 years ago or something, is very hard, almost impossible. But lately it became easier and easier lah. But now it's still not easy. Especially for consumers, you will see later that consumers is not worth it lah. Limitation of damages. So you need to satisfy these two requirements. So remoteness means if you didn't go and tell Mercedes-Benz, I'm going for a holiday, I'm going to use the car for vacation. Mercedes-Benz say, I don't know ma. How I know you got all this, right? So let's say you order something. You tell the supplier, I need the delivery to be done in the next 3 days. If you don't, I will incur a lot of loss. I cannot, you know, meet my other customers' orders. Right? You already go and tell them. So it's reasonable foreseeable that you incur the loss. If they don't perform, then they have to perform. Another test is assumption of responsibility. Okay, so some cases will say you go for assumption of responsibility. Some say you need to go for reasonable foreseeable. So yeah, so you can in exam you have to argue. There are two different authorities. Okay, and also you need to minimize your loss. You cannot like let's say your car break down, but you can call Grab car. You didn't go and call Grab down. You purposely stand under the sun, so you cannot go and claim for this. This is your fault, You didn't go and take reasonable steps to minimize your loss, right? So the moment you have a breach of contract, you have to find a different supplier. You have to find a different contractor to go and finish the job or go and fix the job. Then you can but you must only go up to reasonable lah. You don't go have to take so extreme steps. You know, you just do what is reasonable. The court will decide lah whether you did. If you didn't, then you cannot claim for those kind of damages lah. You can only claim for up to the damages that is reasonable. So in conclusion, we see that contract law is to compensate expected benefits. Actually, the whole aim of contract law is to encourage commercial activity. You know, it's not so much for consumers like you and me. It's more for the courts don't have time to look at all our Shopee and Lazada claims. You know, 50, 100, 200. They want to encourage big businesses to enter into complicated contracts. Then you can have all this risk taking. You know, you have all these there are only people there to enter into contracts because it's so risky So you want to have certainty in the law, right? So it's not necessary for the consumers. Okay, that's why they go for expected benefit because this is a certainty It's people know that this is the law. Okay, but if it's non-financial, okay, it's very hard to claim. That's why in exam they always like to test you on non-pecuniary loss. But in US it's easier. Okay, that's why US I read that they like to sue for all these small things I mean for all these non-financial things they can it's easier. Their law is easier. And you see, if consumer contracts, you engage a lawyer, it will cost you how many thousand, tens, a lot of thousands And you go for small claims court also, you have to represent yourself, you know. Of course, you can get a lawyer to advise you, but you don't know the law, and then you have to argue in the court, and then you have to present evidence. You know, you have to take 2 3 days leave, you know, just for, let's say, just for under 5,000 also. You know, are you so this system doesn't really work for consumers. Like I bought something from, let's say I buy something fertilizer lah. My whole plant, my whole all my things died after I use their thing, you know. Of course they will say I compensate you lah, I compensate you 100 also no problem, 200 also no problem mah, right? But to me it's worth more than that mah, right? So this is but how you want to, so it's not suitable for consumer contracts. To protect consumers, you need more than this. You need like a system where people are yeah, I don't know, but this one is up to is I'm not so smart to design a way to protect consumers lah. Okay, um, yeah, but for me 50 ringgit, just let it go, and that's why a lot of Shopee or what you buy online is dangerous lah. Yeah, you have to be careful, and yeah, so it's more for companies lah. It's more for big corporation because they know how to manage their risks lah. When you know the law, you know you can calculate mah. Let's say anything worst case scenario, how much I need to pay. You know, you it's more certainty lah. Okay. Yep. Thanks.